welcome. I'm Michael Hussey, Dean of Widener Law Commonwealth. It is my pleasure to welcome you to the annual John L. Geddes Lecture hosted by our Law and Government Institute. The Institute helps students explore how government works and the roles that lawyers play in making and implementing law. As a result, our students develop a passion for government law, which in turn leads to Widener Law Commonwealth alumni working in all areas of government law and public service. Our alumni are key to ensuring the rule of law is rightly developed and faithfully implemented. I hope you will find today's lecture engaging and thought-provoking. It is now my pleasure to introduce Professor Jill Family, who is the faculty advisor of the Law and Government Institute. She teaches administrative law, immigration law, and civil procedure, building upon her scholarship that explores the intersection of immigration law and administrative law. Professor Family has served as chair of the American Bar Association section on administrative law and regulatory practice. Additionally, she is an elected member of the American Law Institute. Please join me in welcoming Professor Family. All yours, Jill.
Thank you so much, Dean Hussey. Thank you all so much for being here. This is one of my favorite law school events, and I look forward to it every year, selfishly, because as my students know, I love administrative law, and it's such a pleasure to be able to learn new things and to gain insights into administrative law from these fabulous lecturers who have helped us every year not only put on this program, but also to honor John Geddes, and who this lecture is named after John Geddes. John was the inaugural vice dean of our law school and was crucial in founding our law school, as well as founding the Law and Government Institute, which, by the way, this year is the 25th anniversary of the Law and Government Institute. So for 25 years, we've been able, as Dean Hussey said, to help students begin careers in public service and to really become the best of what government lawyers have to offer. Just a couple quick thank yous. I want to thank Brian and Steph and John for their help in putting this event together, as well as John Geddes for all of his tireless work on behalf of the Institute, and for also agreeing to be the honorary chair of our planning committee for our year of 25th anniversary celebrations. So be on the lookout for more special programming to celebrate the Law and Government Institute's anniversary. So in just a second, I'm going to turn the program over to our speaker, but I wanted to let you know that there will be time for questions and answers at the end of the program. And so if you raise your Zoom hand, I will be able to unmute you to ask a question at the end of the program when it's time. So it's my pleasure to introduce Anne Joseph O'Connell, who is a lawyer and social scientist whose research and teaching focuses on administrative law and the federal bureaucracy. She's the Sweet Professor of Law at Stanford University. She holds a JD from Yale and a PhD from Harvard. Quite simply, she is one of the world's most prominent and respected administrative law scholars. She is a member of the Council of the Administrative Conference of the United States, which is an independent federal agency dedicated to improving regulatory procedures. She is a 3-time recipient of the American Bar Association Scholarship Award in Administrative Law for the best article or book published in the preceding year. And she is a 2-time winner of the Richard D. Cudahy Writing Competition on Regulatory and Administrative Law from the American Constitution Society. She is an elected fellow of the American Academy of Arts and Sciences and the National Academy of Public Administration. She frequently consults with congressional staff, nonprofit organizations, and others, and has testified in front of Congress. She clerked for Supreme Court Justice Ruth Bader Ginsburg and for Judge Stephen F. Williams of the U.S. Court of Appeals for the D.C. Circuit. In between her clerkships, she was a trial attorney for the Federal Programs Branch of the U.S. Department of Justice's Civil Division, receiving commendations for her work. Earlier in her career, Professor O'Connell worked for a number of federal agencies, including the Department of Defense, the Federal Trade Commission, and the U.S. Army. So please join me in giving a warm welcome to Professor O'Connell.
Thank you so much to Dean Hussey, to Jill Family, Rob Teplis, and many others at Widener University Commonwealth Law School. I'm honored to give the 2024 John L. Geddes Lecture today. The Law and Government Institute, founded and initially directed by Professor Geddes, is impressive. I share his commitment to improving government law and practice. And although this is my 20th year of law school teaching, and I'm particularly excited that there are some admin law students listening, as administrative law is the mother subject, my formative experiences are actually in government agencies. So starting in the Reagan administration, I was one of those American high schoolers who benefited from STEM opportunities. I worked all of my high school summers and college summers for the United States Army in health physics research, looking at X-ray backscatter to detect landmines. And it continued from there between college and law school. And then all 3 summers of law school, I worked for government agencies, starting with the Department of Defense General Counsel in my first summer, splitting my second summer with the Federal Trade Commission. And I was not going off to a firm with a bar stipend, so in order to pay my rent, I worked while studying for the bar, and I worked for the Office of Legal Counsel in addition. I do have to admit that I am particularly excited about my latest foray into government service, and that being an appointee to the Council of the Administrative Conference of the United States, because for the law students in the room, I actually received a presidential commission, thinking of Marbury v. Madison, signed by the President and Secretary of State. Now it is rolled up somewhere in my closet, but exciting nonetheless. So let me share my screen. I have some slides to help with my lecture today. Hopefully you are seeing the slides. So I'm going to talk about removals and anti-removals in federal agencies. And my plan for the next 35 minutes or so is to provide a little bit of motivation for this project. I'm working on a law review article to talk about the main claims. So to give you, because it is too long and you don't have anything to read, the short version of what I believe to be the claims that I'm trying to make, talk a little bit about the types of removals and anti-removals, the law and litigation surrounding them, norm and strategy, and then perhaps a bit different from other work on removals, which largely focuses on constitutional issues and separation of powers, to talk about some empirical work I've done about the removal of at will, that meaning the president can remove them for any reason, Senate confirmed leaders in federal agencies. And from that empirical work, looking from the start of the Carter administration to the end of the Trump administration, what that might suggest for what could happen with regard to the firing of commissioners and board members who currently enjoy removal protection. But that removal protection, I would say, many commentators would say, probably won't last long, that the Supreme Court is poised, I think, to overturn Humphrey's executor. And so what might we take from this empirical work on executive agencies and what it might say about removals in the independent agency arena? And then I have some closing thoughts that maybe we're too focused on removals and maybe we should focus much more on hiring. All right. So the motivation of this project on removals is because removal seems to be taking more and more of my time in teaching structural constitutional law and administrative law. And that is because of some recent Supreme Court decisions. And these decisions most widely are thinking about agency control. But when thinking about agency control, they think quite narrowly about one form of control, that being removal of agency officials. And then in these cases, the idea of thinking about removal of agency officials is also narrowly considered. And that's the idea of, is there unfettered ability to remove, to fire an agency leader. And so for the students in the room or those who are followers of the Supreme Court, kind of many years from law school, right? The types of cases that we're thinking here are Saylor Law, which was about the removal restriction on the head of the Consumer Financial Protection Bureau, where a majority of the court said that the removal restriction on the president's ability to remove the head of the CFPB violated the separation of powers. That decision was followed by the Collins decision, which involved the Federal Housing Finance Agency. Similar to the CFPB, the FHFA was headed by a single director with a removal restriction. There too, a majority of the Supreme Court held that that removal restriction on the president's power violated separation of powers. And then before that, we had the Free Enterprise Fund, which involved what is known as double for-cause removal on the members of the Public Company Accounting Oversight Board. I think it's my favorite agency acronym, peekaboo. And the statute, Sarbanes-Oxley, had created removal restrictions on the peekaboo members that the SEC commissioners could remove them only for cause. The Supreme Court assumed that the SEC members could also only be removed for cause by the president, even though that's not written into the SEC statute. This was known as double for-cause removal. This was seen by a majority of the Supreme Court to violate separations of powers principles. And we currently have a lot of litigation, including in front of the Supreme Court this term, about administrative law judges of the Securities and Exchange Commission, who are also sort of seen to have double for-cause removal protections. So there's all this attention. I think it's too narrow about control being removal and removal being too narrow about firing, but it does propel the question, as we see with changing court composition and these recent cases, especially in Saylor Law, really kind of questioning Humphrey's executor, though not overruling it, though Justice Thomas in concurrence would overrule it, is I do think that many think that Humphrey's executor, which provides removal protection to multi-member-led agencies, so the CFPB and the FHFA were single-led agencies, but what about the NLRB or the Federal Trade Commission or the Securities and Exchange Commission, which are multi-member-led, who either have explicit or assumed removal protections? When that is overturned, what's going to happen? So that was a big motivation of this project. And then in combination, at the end of President Trump's administration, there was Schedule F, which did not get off the ground because it was, in a way, started too late. But of course, any Republican coming into the White House has promised, and President Trump himself, if he were to be reelected, has promised to return to Schedule F. And also the motivation there is, if I were a conservative, why might I oppose Schedule F, right? So I want part of the motivation of the project is not a position from the left saying Schedule F is bad, but a position from the right to say, does this make sense strategically to have something like Schedule F, which would remove removal protection from even more officials? All right, so the main claims that I want to make today include the following. So one, that removals encompass more than firings. I'm going to talk about different types of removals. That there are also anti-removals. There are mechanisms that kind of keep people in place when you might expect them to leave. There's a considerable amount of law and legal questions that surround removals and anti-removals, including some modern Frank Myers and William Humphreys. So Frank Myers was the postmaster who was removed in the Myers case, and William Humphrey was the Federal Trade Commissioner who was removed in the Humphreys executor case. Until very recently, our separation of powers cases have not involved plaintiffs who have been removed. Instead, they are people facing enforcement actions, for example, by an agency where there are removal protections. But interestingly, we have some modern Frank Myers and William Humphreys, including Sean Spicer and Roger Severino, who I'll mention a little bit later. I also want to note that removals are common in modern administrations, even outside of President Trump. So, of course, there was much attention paid to President Trump's removals, right? Just thinking about his cabinet, he pushed out Tom Price, Health and Human Services, David Shulkin, Veterans Affairs, Rex Tillerson, State Department, Ryan Zinke, Interior, Kirstjen Nielsen, Homeland Security, Alex Acosta, Labor Department, Kevin McAlean, an acting Secretary in Homeland Security, Mark Esper in Defense, and sped up James Mattis's departure at the Defense Department. And although, right, just today in the Washington Post, there was coverage of the Partnership of Public Service talking about the stability of President Biden's cabinet, but President Biden, too, has done some removals, right, including recently of an inspector general. Part of what, after President Trump trying to, and succeeding in some cases, removing certain IGs and the controversy that surrounded that near the end of his administration, President Biden campaigned on a promise not to fire any inspector general, and he hasn't yet fired the IG of the Department of Homeland Security or Social Security, where he's facing a lot of pressure to do so. But he did recently announce he was going to remove the IG at the Railroad Retirement Board due to a toxic work environment. But President Biden has also fired people, right? After the Collins case, President Biden fired Mark Calabria, who was at FHFA, not waiting until a challenge to the Social Security Administration reached the Supreme Court. President Biden fired Andrew Saul as Commissioner of Social Security. He pressed Kathy Kraninger, who had been the head of the CFPB to resign. Now, all of those people, Kraninger and Calabria and Saul, had initially been picked by President Trump, but President Biden has also picked some of his own people to leave federal agencies. So I'm also going to provide more information, kind of going past President Trump and President Biden. I want to make a claim that unfettered removal power can actually hurt those wielding it. So I think that many assume that the president should have full removal power because it helps with presidential control and helps with policy implementation. And I want to make an argument that that is not the case. I want to argue from some empirical work that when Humphrey's executor is overturned, that there's not going to be chaos. And that we might even get the true myth of independent agencies. We might get agencies that are evenly split because of quorum requirements and Senate politics if Humphrey's executor is overturned. Now, with Schedule F, that involves more people than what Humphrey's executor would impact. I think there wouldn't be considerable chaos under Schedule F. I'm not a fan of Schedule F, but I want to make an argument that there would not be considerable chaos if people are thinking strategically about performance as opposed to rhetoric. Now, there are also further calls to go beyond overturning Humphrey's executor, beyond overturning Schedule F, to removing protections for the civil service. And I think without civil service removal protections, that's where I think you would see chaos. And then I want to, at the end, say maybe we're talking all this stuff about removal. Maybe we should talk about something other than removal, which is intimately tied to removal, that being hiring. Okay, so one of my first claims is that removal includes more than firing people. So preliminarily, I should say that presidents firing top agency officials is relatively new. So prior to President Truman, when he took office in 1945, many cabinet secretaries stayed over into the next administration, right? We had 27 attorneys general, 26 secretaries of the Treasury, 23 secretaries of state that kind of kept serving from one administration into the next. I mean, President Andrew Johnson was impeached in part because he fired Edwin Stanton, who had been President Lincoln's pick for Secretary of War. So historically, a lot has changed, but in modern times, we do have removals, right? You can just think about the Secretary of Defense. So I mentioned President Trump firing Mark Esper and removing James Mattis earlier than he wanted to leave. But President Obama pushed out Chuck Hagel, President George W. Bush asked Donald Rumsfeld to leave, and President Clinton kicked out Les Aspin, right? So the kind of standard definition of removal, modern practice, is firing or asking someone for their resignations. But there are other ways that removal operates in practice. One of those ways is presidents gathering offers of resignation and then deciding later which ones to accept. So there's a norm that's developed when administrations change. These letters are supposed to come in, and the new administration then chooses which ones to accept and which people they actually want to keep and hold on. But sometimes it happens outside of transitions. On the slide, President Carter had a lengthy, according to one news report, a serious and lengthy discussion with his cabinet and senior White House staff in mid-July 1979 about the priorities of administration. And he basically got all members of his senior staff and cabinet to offer their resignations during a period of evaluation. And in the weeks that followed, President Carter accepted 6 of these offers of resignations from his cabinet secretaries. So there is this idea of kind of gathering letters and then deciding which to accept. And then I think less commonly known or less commonly thought of as removal is that the White House or agency heads, if we're talking about lower level agency officials, can change the conditions of the job such that the people in the job want to leave. So some examples would include in the last administration, the Department of Agriculture relocated its Economic Research Service and its National Institute of Food and Agriculture. Bunch of people who had been in those agencies in the DC area left, as opposed to going to the Kansas City area. We also had the move in the Department of Interior in the last administration of the headquarters of the Bureau of Land Management to Colorado. That move has since been reversed, but many people left there, right? So those are different types of removal in the executive branch. Or coming from the executive branch. There's also removal by Congress. So obviously the most obvious, the biggest one is impeachment, right? We have the first impeachment since the impeachment in 1876 of the Secretary of War, William Belknap, for taking bribes. That impeachment actually occurred after he had resigned. But in February, after a failed attempt by one vote, the House of Representatives impeached Department of Homeland Security Secretary Alejandro Mayorkas with regard to his border policies. And those articles of impeachment have just been sent to the Senate. So that I think most people think of in terms of how can Congress remove agency officials. But there are 2 other ways I want to flag, I think, that are less thought of, is that there are congressional statutes that can prevent certain officials from being paid, which means that can force people to leave, because there's also a statute that says that people cannot volunteer for the government, work for free. So where does this come up? This comes up especially with regard to acting officials, that once someone who has been nominated to a federal agency position, if their nomination has been withdrawn or returned twice to the president, that person can no longer be paid for carrying out the functions of that job, right? So you could think about Julie Su, who is the acting Secretary of Labor. Her nomination has been returned once. Once her nomination is returned twice, she can no longer be paid for carrying out the functions of the Secretary of Labor position. The second, less commonly thought of mechanism for Congress to remove agency officials goes back over 2 decades for me. So my PhD dissertation, I was also interested, though I have gone on to other topics, but maybe you could say I'm coming back 20, 25 years later to my dissertation. My dissertation was also about removal. And the question was, Congress cannot formally remove executive branch officials, right? Think Bowsher. With regard to Graham Rudman. But my question was, what if they could make the life of federal agency officials so miserable that they left? So what they couldn't do formally, they could do functionally. So I think another removal mechanism, and I did some empirical work for my PhD dissertation that at least suggested a correlation between more hostile congressional hearings and shorter tenures. And then finally, in terms of categories, in terms of the branches of government, in terms of removal types, would be that the courts can disqualify in administrative law in very extreme situations decision makers. Now that's disqualifying decision makers from certain policies as opposed to removing them themselves. And then of course the officials themselves can remove, right? Can self-remove. And the big one here that I want to think about is also resigning in protest. So if you think about types of anti-removals, kind of keeping people there as opposed to pushing people out, there are 2 categories I want to quickly flag. So there are holdovers. And so holdovers include fixed term appointees after a term ends. So the statutory language on the slide is about the Federal Trade Commissioner, which says that a commissioner can be held over, right? They have a term of 5 years, but they may continue to serve after the expiration of the fixed term of office of the commissioner until a successor is appointed and has been confirmed and taken the oath of office. Now, there's a condition on that in C. Now, there are also holdovers where across White House transitions of at-will appointees. So these fixed-term appointees with holdover provisions typically have removal protections right now, but there are also at-will appointees who who are held over across White House transitions. So Robert Gates as Secretary of Defense might be an example or is an example of that. And then the other type of anti-removal is burrowing, which has 2 kind of subclasses. One is the more typical one where we think of people who are in political slots who then transition into career slots, and we call that burrowing, right? Burrowing into the career civil service. That has to go through OPM review. But there's also burrowing of appointments. So other than President George W. Bush, all modern presidents have tried to nominate people to Senate-confirmed jobs after the election and even in the first few weeks of January before the inauguration of a new president. And some of those kind of go through. Now, President George W. Bush in January, he's the only modern president who did not submit kind of any significant numbers of these midnight appointments. All right, so what to take from all of that? A bunch of categories, but it's to say that removal is broader than the president firing in agency officials. So I want to spend a few minutes talking about law and litigation of removals and then provide some empirical data. So I have this kind of broken out into 3 categories. So there's law and litigation surrounding Senate-confirmed officials, number 1. Number 2, there's law and litigation surrounding non-Senate confirmed officials, but who are political appointees. And then 3, there's law and litigation surrounding career workers. So I just want to say a few things about each of those categories before turning to some empirical work and predictions if Humphrey's executor is overturned. So with regard to Senate confirmed officials, what we learn in structural con law and administrative law is that these early provisions, and they were common to some degree, of requiring Senate acquiescence to remove a Senate confirmed official, no longer operate, right? So one was struck down in Myers, where postmasters could be removed by the president by and with advice of the Senate. That was struck down. But interestingly, we still see Senate acquiescence in some positions, which are seen not to be executive branch officials. So it turns out the head of the Government Accountability Office, still to be removed, needs a joint resolution of Congress, and there are 4 cause restrictions as well. In terms of other law on removal of Senate and the Comptroller General is a Senate confirmed official. So there are still some restrictions on presidential removal, on multi-member commissions and boards, right? We still have Humphrey's executor in place, though it's being heavily challenged in the lower courts. Now, what's interesting about the law here is that you could be a commissioner, like at the Federal Trade Commission, which is Humphrey's executor. You have 4 cause removal protection, but if you are held over under that holdover provision I just read from, you actually don't have removal protection in the holdover period. And that's true too of acting officials, the limited places where we've had acting officials where the confirmed position had removal restrictions. We know that the removal restriction does not extend to the acting. Now, we have a lot of removal restrictions in place for these multi-member agencies, but what's interesting, I think, is the single-headed agencies. After Collins, after Saylor Law, we don't have removal restrictions on the single-headed agencies, but I don't know how many people realize that close to 24 single-headed agencies have fixed terms on the number 1 person, right? So the director of the census has a 5-year term, for example. And so we still do have some restrictions on the tenure of Senate confirmed agency officials. We also have reason giving for certain Senate confirmed officials. So as I mentioned, President Biden has said he's going to remove the IG of the Railroad Retirement Board. The statutes require that when the president removes IGs, she has to give notice to Congress 30 days before that removal. There are 2 Senate confirmed jobs at the VA, the medical director and benefits, where a notice has to be given with regard to removal. Interestingly, on the law surrounding Senate confirmed officials, something I learned recently is that for 3- and 4-star generals, they actually need permission to leave. They actually need the Department of Defense Secretary's permission before they can retire. There was some issue here with regard to the holds by Senator Tuberville and getting kind of people up through the ranks, and some people who wanted to retire were not allowed to retire. And then what I want to say, so there's a bunch of law surrounding the removal and the keeping of Senate confirmed officials, is I just want to flag like what's going on in the courts that's active. I guess I want to flag 3 things. Is 1, although we focus on Saylor Law and Collins, there are other cases involving removal law. So there are cases about the Social Security Administration and whether that removal restriction violated separation of powers principle. There was a 9th Circuit case, never made it up to the Supreme Court. There are cases about holdovers not receiving removal protection. There's one from the Credit Union Administration. So there are these big cases we study, but there are also these other cases out there. The second thing I would say is what we're seeing now in the courts is that there's a lot of litigation going on about, does the restriction on removal actually create harm to those suing? And that kind of relates to standing questions, but it also relates to remedial questions. So Collins about the Federal Housing Finance Agency and the 3rd Amendment with regard to dividends of Fannie and Freddie, right, gets kind of remanded back for a discussion about what really was the harm from the removal restriction, when most of what was done with the Third Amendment was actually done by an acting official who didn't have any removal restriction. And then the third and final thing to flag about kind of recent litigation is that there are a considerable number of challenges to these removal restrictions on independent regulatory commissions and boards. So in the courts of appeals and the district courts right now. So we have challenges to the Consumer Product Safety Commission. We have challenges to the National Labor Relations Board. We have challenges to the Federal Deposit Insurance Corporation. We have challenges to the Federal Trade Commission. So Humphrey's executor and its longevity is kind of on the table and percolating its way up. Wrong direction. The second category, I'm not really going to say much here about political appointees who are not Senate confirmed. We do, because of Morrison, allow some restrictions on presidential removal. We have a bunch of fixed terms on non-Senate confirmed presidential appointees. We have reason giving for the independent counsel, which is no longer existent. We have reason giving for the special counsel. The one thing I want to flag here is what I think is the most interesting in this category are the modern Frank Myers. So these initial removal cases were about people who wanted money because they were fired for their government positions. And then we started to get all these removal cases, which were not about people getting fired. Instead, they were about people who were facing some action by an agency who was led by people with removal restrictions. But in recent years, we're getting some modern Frank Myers and William Humphreys, and they're not seeking money, right? They're not seeking their government salary. Instead, they're seeking replacement. They want their jobs back, or they claim to want their jobs back. And I should admit, I have a conflict of interest in a sense, because one of these plaintiffs, Roger Severino, was a midnight appointment to the Council of the Administrative Conference of the United States, okay? So he had an earlier appointment, but then he got a later appointment kind of in the final weeks of President Trump's administration. So it's a presidential appointment to the Council of ACUS. There is a term, there's a 3-year term. There is no explicit removal restriction. Once he was fired, he was asked to resign, but refused to do so. He was fired. I was then appointed to the Council of ACUS. So in a sense, I kind of took his job. And he brought suit. And he argued that he wanted his job back. And there were similar suits with regard to Sean Spicer and Russell Vought, who were on military academy boards, who were also removed that had fixed terms. In all of those cases at the lower level courts held that the fixed term did not provide removal protection, and hence that the firings could occur. And then there's also the kind of Leandra English at the CFPB there on that kind of acting side. But I kind of like this kind of modern Frank Myers and Williams Humphreys that we're starting to see in this category. And then finally, in terms of career and SEC workers, this is in a way what we don't teach in administrative law. I mean, we teach the due process clause cases. If you have an entitlement to a government position, then due process clause would attach, and then we would think about the process you would have if you were to be removed. But there's a ton of case law and a ton of statutes and regulatory apparatus about removing career and SEC workers from federal agencies. So I'm not going to kind of get into this, but there are some really interesting questions here, both about career workers in the competitive service and then the senior executive service. So as I move into thinking about what's going to happen if Humphrey's executor is overturned and what's going to happen with regard to Schedule F and how we should think about it all, I want to just kind of raise some of the strategy that presidents have to consider, that officials have to consider if they're thinking about resigning in protest, and Congress has to consider in thinking about impeachment or in oversight. is to make some arguments about the strategy of removing someone, right? Because there are benefits and there are costs to removal, right? Could be something about a policy change, could be about signaling, could be about power. Of course, it matters how easy it is to get a replacement. I mean, what's interesting about cabinet departments is that if you remove a cabinet secretary, you have the Vacancies Act and many specific agency provisions that allow for acting service without getting Senate acquiescence. Now, there are appointments clause questions to how long an acting cabinet secretary could serve who is not confirmed to any position, but there's kind of easy replacements if you get rid of the Secretary of Defense. Whereas there are not easy replacements if you get rid of someone at the Federal Trade Commission, because the Federal Vacancies Reform Act doesn't apply there. Thinking about replacements is kind of key into the strategic consideration. So here's the one point I want to make about the strategy is that those in favor of getting rid of removal restrictions may end up hurting themselves, right? And what do I mean by this? Well, a couple of arguments. So number one, in free enterprise with the double for cause removal of the peekaboo members, Justice Breyer in dissent pointed out the scenario where the president wants to keep a peekaboo member, but the SEC wants to remove them, right? There, having the removal restriction of the SEC on the SEC helps the president, right? And in free enterprise, that was what got severed, right? Was the removal restriction on the SEC. So, right, sometimes actually the president's power can be enhanced by having removal restrictions. Outside of this double for cause context, removal restrictions can also benefit policy-wise. So there's a picture here at the bottom of the Fed, and we have removal protection on the governors of the Fed. And many economic studies that to the extent that the Fed has independence, the better for the economy. So there, and I do think there is, I think even though Humphrey's executor might get overturned, I think the Supreme Court is going to come up with a way of preserving the Fed, right? Removal restrictions on the Fed are going to remain if I'm to predict, they might go away at the Federal Trade Commission, but they're not going away at the Fed. They're not going away at the Fed for a variety of reasons, but I think because the removal restrictions on the Fed have such beneficial policy consequences. Then there's this whole social science literature about removal restrictions actually being tied to better performance, to lower corruption. And then what's interesting is some work by Sean Gilmard and John Patty that by giving independence and discretion and providing insulation and protection from removal in these game theory models, that you can actually show that that's better for the development of expertise as opposed to a system where there's total control by the principal. So getting to the empirical information and the predictions of Humphrey's executor, I should note these are preliminary results. I have a large database, over 1,100 at-will Senate-confirmed officials in executive agencies and departments. It includes the number 1 person, it includes the number 2 person, and then it includes a subset beneath them of policy-making positions. So there's something called the Plum Book, which lists out kind of all policy-making positions, actually has a plum cover. But John Tratner, some decades ago, did the Prune Book, which was a subset of the Plum Book of the most policy relevant. So all of the Prune Book positions are in there. And if you look at these 1,100 appointees, I think what's interesting is that firing happens, right? And being pushed out happens. So 19% of these Senate-confirmed officials are pushed out. They're either fired, officially fired, not so much. Pressed to resign, bigger. Conflict with the White House from news reports, bigger. Under criticism from Congress or the media, a little smaller. If you take out the Congress and the media from the news reports, 14% of these at-will Senate-confirmed officials are kind of pushed out because of the White House. 11% left for a higher job in the executive branch. So a stepping stone, they leave from one position to a higher position. Under 1% resign in protest. Interestingly, dominant, right? 43% left because it was the end of the term or the administration. And then in terms of holdovers, 14% of them stayed at least one full day into the next administration. And the largest chunk of those, as you might expect, was the same party transition from President Reagan to President George Herbert Walker Bush. So if I'm thinking about what's going to happen here with regard to Humphrey's executor being overturned, is that you're going to get some people pushed out. Now, in terms of career officials data, this often gets cited by those who want civil service protections to be removed or heavily revised. The figure they often cite, well, only 4 million career workers out of nearly 2 million were removed for performance or misconduct in a recent fiscal year. But what's interesting here is that the MSPB surveys of managers seeking removal show that 54, so these are, they ask for all the people you wanted to get rid of, what happened to them? Like that you took actions about, what happened? And 54% were removed, so they're part of the 4 million, but 28% resigned. And 8% retired, showing that kind of a broader definition of removal is also important here to think about leaving the competitive service. And what's interesting is when you ask managers in government agencies, like, what's the biggest barrier to removing like a poorly performing agency worker? It's not the standards of Chapter 43 or Chapter 75. They cite it's the culture, it's the, their manager's support for any adverse personnel action. And then also, right, there's a kind of pathway through the MSPB, the Merit System Protection Board, to contest removals. But there's also the Equal Employment Opportunity Commission, and that is seen as a kind of big barrier. And what in terms of self-removals, we have huge resignations going on in federal agencies right now. All right. So predictions, so that we can have a few, at least, hopefully I'll finish in 2 minutes. We have 10 minutes for questions. We already have disappearing commissioners. There's some really interesting work by Brian Feinstein and David Zering that the average tenure of commissioners, these are the people who have removal protections, has already dropped. So I don't think we're going to see a huge number of removals. I think we might see that kind of 14% number. I think the strategic calculation here, though, is very different than at will, than these officials at executive agencies. Because at executive agencies, you have the Federal Vacancies Reform Act, which allows for easy placement of acting officials when you get rid of someone. That is not true at independent regulatory commissions and boards. Now, would you amend the Federal Vacancies Reform Act? But assuming that's not amended, you don't have actings, you need Senate confirmed officials. I think what you're going to see are evenly split commissions. Even now, we have a Democratic Senate, President Biden in the White House. It took over 2 years for the Federal Communications Commission and the EEOC to get a Democratic majority. If the Senate has opposite parties, I think what you're going to see are evenly split commissions. Many quorum rules of these agencies are 2 members. And so if the president were to fire one, I think you're only going to get confirmations up to the quorum, which is then going to put pressure on the president not to fire, because if the president fires, you're not going to have a quorum and the agency is not going to operate. And so the quorum rules, Senate power, all going to kind of play in. So I think you're going to have even fewer removals than you have of the executive agencies if or when Humphrey's executor is overturned. Now, the one final thing I'll say about this is that, kind of ironically, I don't know if that's the right word, is that we might, if Humphrey's executor gets overturned, end up with the classic myth of a nonpartisan, multi-member independent agency, because we are likely to end up in many kind of configurations of having commissions and boards with 1 Democrat and 1 Republican to kind of meet the quorum rules to operate. So you're going to have kind of evenly balanced commissions. And the last thing I'll say, I'm more in Q&A, I can talk about proposals of Schedule F and the kind of broader proposals about the civil service. But I'll close with this one sentence, is I think we're so focused on removing agency officials and agency workers and all the conflict that surrounds that. But it seems to me like the biggest problem, and one that really is not getting enough attention, is hiring. Like, it just takes too long, right? For Senate confirmed people, it takes too long to get Senate confirmed people in. That's the attraction of the actings. And then for career workers, it's the federal hiring process is too long. It's too long, and we really need to focus about getting people in. And then maybe once they're in, if we're worried about poor performers, maybe we should think more about carrots, performance awards, etc., as opposed to sticks and the threat of firing. And you can't think about firing without thinking about hiring. So I'll close there. Thank you.
Thank you so much for that really interesting discussion. And I think probably most people on the Zoom know that administrative law is undergoing something of a revolution, in that it's an area of law that we used to think was pretty staid and not changing very much. And instead, now we're in a situation where lots of administrative law doctrine that we thought was settled now suddenly appears to be unsettled. And this talk is a prime example of that. And so we're so happy to be able to engage on a topic that not only is so interesting, but is so timely as well. So we do have some time for questions. So if you have a question, if you want to go ahead and raise your Zoom hand, I will be able to recognize you. And also, Brian, I would say if John Geddes has been able to join us, now also would be a good time that we could recognize him. I thought I saw him earlier, but maybe he had to.
He's still on here.
Oh, okay, great.
He just put up there. So welcome, John.
John, we're so glad to see you. Welcome to another Geddes lecture in your honor. And so I'll go ahead. It looks like Christine has a question. So if you could just unmute yourself, Christine.
Hi, really enjoyed the talk, and I was just curious to get your thoughts on the prediction that the court will overturn Humphrey's executor. I agree that's accurate based on what they said in Celia Law and Collins, but also at the oral argument in Jarkissi, they seemed very uninterested in this particular question, and just wondered if maybe they're going to back off, go a different route, or maybe the issue in Jarkissi is different from those other cases. So interested to hear your thoughts on that.
Yeah, so I taught administrative law in the fall, and my very last class was the day of oral arguments in Jarkissi, and it was the one day I had assigned to Article 3 issues in administrative law. And in my lecture notes, I had maybe 3 sentences about the 7th Amendment. And because of the time difference in California, I was able to kind of get a sense of the oral argument right before I walked in to teach administrative law. And some of you may know this or not know this, is that the oral argument, Jarkissi raised 3 claims. One claim was about double for cause removal on the administrative law judges. A second claim was a non-delegation claim that the SEC choosing between ALJs or going to federal court didn't have, according to those challenging it, an intelligible principle. And then the third was that the in-house ALJ process violated the 7th Amendment and Article 3 considerations. And administrative law people, like the administrative law listserv was all a buzz. It was like all focused on one, right? This double for cause removal. And there's like a little chatter about the second, but there was almost like no chatter about the third. And it turns out the oral argument was almost entirely focused on the third, right? And seemed like there was little attention. So I don't know how much that tells us about the fate of Humphrey's executor. I think it tells us that the SEC's in-house adjudication process is likely to fail on 7th Amendment grounds. It postpones for a bit the question of double for cause and adjudicators. And even if there's not a majority to overturn protections on ALJs because they're different, they're adjudicatory, maybe there's due process, who knows, considerations. I think the idea of people who are not primarily adjudicating, so Lena Khan heading up the FTC, doing a lot of policymaking, and you could give examples on the right as well, right? That kind of removal restriction, I think, is much more in danger. And when you're reading these lower court decisions, so there was just a decision on consumer research versus the Consumer Product Safety Commission, which was a court of appeals, pretty sure it was the Fifth Circuit. And it basically said, listen, under these latest cases, these restrictions are not constitutional, but Humphrey's executor has not yet been overruled, so we're kind of bound to uphold the CPSC, but really it's coming. And I feel like it seems to be a sentiment that it's coming. And I guess my view is I'm a fan of Humphrey's executor, but I think when I think about policy consequences, the overturning of Humphrey's executor, it's going to fundamentally shift independent regulatory agencies, right? Really going to shift them, because you're going to get these, I think you're going to get these evenly split commissions. You're not going to get Lena Khan-led FTCs anymore. But I don't know if the left or right is upset by that. They could, if they have unified power, right, change the structure so you have single-headed agent, but you could get rid of quorum requirements. Now, interestingly, the FTC may be the wrong example. So I was one of the very few people in Sailor Law who was arguing about the FTC and Humphrey's executor, because there was this whole discussion about single-led versus multi-member, right? That becomes a huge thing in Sailor Law. Well, it turns out that there aren't that many multi-member agencies that don't have quorum requirements, but the Federal Trade Commission is one. So the Federal Trade Commission can actually operate with one commissioner. So that whole difference between like single versus, I was like, but you're doing this all in the FTC, but it could actually be led by one. So I think there will also be questions there. But I do think Humphrey's executor, it's not looking good for Humphrey's executor.
Thank you.
Other questions? I'll throw one out there. So when you talk about evenly split commissions, my question is, does that necessarily mean independence, or does that just mean gridlock? So is the agency not being able to accomplish anything? Is that the same thing as independence?
So it's a fair point. I mean, some of these agencies have statutory provisions that allow review of deadlock. They're kind of norms set, like, so FERC is an example where you have deadlock and the kind of statute kind of allows for certain things to happen because of that. And deadlock can mean a decision. Now, in other agencies, that's not true, right? Deadlock, if you don't have a majority, you don't have an action that the agency can take or something that the court could review. And so I do think you're right, Jill, that in some cases, right, if the Democrat and Republican can't agree, right, that agency will not do anything, right? Or so you might get agencies that agree to do things where the partisan pendulum is not swinging. Like, we're not going to get net neutrality, not net neutrality, net neutrality. You know, like you're gonna get things where the two members are going to come to agreement on something.
Any other questions?
I should say for governance, that I don't like, I do think it would be bad, right? I think for those who think that, for those who want the government to do more, I think having evenly split commissions will hurt that, Any students?
Any other questions? Well, thank you so much. We appreciate your time, and we hope that you have a wonderful end of the week.